Welcome back. So the battle between Nkosana Makate, who is the inventor of the Please Call Me service, and Vodacom, South Africa's largest mobile network operator, is back at the Constitutional Court this morning. It marks the second time that Makate will argue his case before the Apex Court as he seeks fair compensation for his groundbreaking invention. The litigation around that is well underway. Let's listen in.
We say each time, on each occasion, there's a certain submission which a certain party thinks was very important. And we say that and we accept that just because that submission is not in the judgment, then we are clothed with jurisdiction. Yeah. That is my worry, that if we accept your invitation, then it would mean that for us to be clothed with jurisdiction, we would have to nitpick a judgment. And parties would have to nitpick a judgment and look at issues that they raise or arguments they raise. And if those are absent in a judgment, persuade us that, in fact, we have jurisdiction.
Justice Chiki, again, you're absolutely right. And as you know, there is much learning on precisely that proposition, that the mere fact that something was not articulated in a judgment doesn't mean that the court did not take it into account. And for that reason, one takes a realistic approach in the assessment of any judgment. I accept that entirely. But this is not such a case. The court did not recognize the issues before it. The court did not recognize the evidence before it. The court did not apply any of the evidence to any of the issues. We're not complaining about a court's failure to take this into account or that into account. What we're saying is that there was a fundamental failure of the judicial process because the court didn't observe the fundamentals of decision-making by recognizing the issues, recognizing the evidence, and determining the issues on the basis of the evidence. So I submit with respect that it is fundamentally different, and I would also suggest that your judgment would obviously make it plain that this is not a case in which a court is criticized for not mentioning a piece of evidence or an issue in its judgment. This is not a case in which a court is criticized for overlooking a little bit here or a little bit there. The SCA majority failed altogether to identify the issues, to identify the evidence, and to determine the issues.
My next question is whether Section 34, the purpose thereof, is not really focused on the procedure, whether a person has had a right to a fair hearing. And if you've had a right to a fair hearing and a judgment is imperfect, can you then rely on Section 34?
Well, Section 34 entitles one to a fair hearing, which this court has held is fundamental to the rule of law. And a fair hearing would include a fair determination of the issues before the court on the basis of the evidence before the court and the submissions of the parties. In this case, the court disregarded the issues, disregarded the evidence, disregarded the submissions, and didn't even determine the issues. So we submit that it was a fundamentally unfair hearing because the court did not determine the issues on the evidence before it.
Mr. Trengrove, you do know that in this court, I'm assuming you do know, because of your take this as a compliment. You are aware that this court is inundated with applications for leave to appeal. I'm thinking that if we start entertaining purely factual, private, contractual matters, we will not be alive to what the Constitution tells us to be the jurisdiction of this court.
No, that's quite correct. And this court has made it absolutely clear that a mere dispute of fact does not engage the jurisdiction of this court. And even a constitutional issue, well, even a dispute of fact under constitutional garb also does not trigger the...
Even a misapplication of the law.
Yes, indeed. But we submit with respect that it is fundamentally different when a litigant complains that I did not have a fair hearing. In fact, I did not have a hearing at all before the Supreme Court of Appeal. Because a hearing, performance of the judicial function under Section 34 does require an identification of the issues, identification of the evidence, and application of the evidence to the issues. Now, if a court performs that function, then the mere fact that it might make mistakes in doing so is not a constitutional issue, and this court will not afford leave to appeal. But when the court fundamentally fails to perform that very basic judicial function at all, then we submit with respect that that is a constitutional issue. That's a breach of the rule of law, because the court did not even perform the judicial function substantively as opposed to perhaps formally.
Well, in this case, what you are saying, because in your submissions you compared the majority judgment and the minority judgment. And what I'm understanding to be a complaint is not that you did not get a fair hearing. You are simply saying, even when you compare the majority judgment and the minority judgment, there are certain issues that were taken into account by the minority judgment, meaning that you did get an opportunity and you did get a hearing from the court, and it was fair. But you are saying that the majority, as compared to the minority, did not deal with those matters. And this is where I struggle to find the whole issue around fair hearing. And then think that perhaps one then would be tempted to look at a judgment and look at what is in the judgment. Because as you say, we don't know if the majority, some of these issues that you've referred us to, I think there are about 8 of them, occupied the minds of the majority or not. But it's just that they are, as you say, not very clear on the judgment.
No, with respect, our complaint is not that they were not very clear. They were absolutely clear. And what is absolutely clear is that they didn't identify the issues, didn't identify the evidence, made a long list of incomprehensible statements about the issues and the evidence which were simply inexplicable. So that our complaint is that they didn't consider the issues, the evidence, and didn't decide the issues. Now we invoke the comparison of the minority judgment, for which we are grateful, because it illustrates what a proper exercise of a judicial function would look like in a case such as this. But we don't suggest that the majority is wrong because they differed from the minority. Our complaints would have been exactly the same, even if it had been a unanimous judgment. It's got nothing to do with a comparison between the two. We merely suggest, and we illustrate our point, that the minority did.
All right, that's the situation as it unfolds in the Constitutional Court, sitting in Braamfontein. Of course, the please call me matter back there for a second time. Nkosana Makate being quoted in the media saying that he hopes the court's outcome will bring finality to this back and forth between him and Vodacom, which has literally spanned for years. Speaking there is Rim Trengrove on behalf of Vodacom as they go through the different technical aspects of the relief that they are looking for in that particular court. We'll keep listening in for you. The stakes very high there. As soon as there's any outcome, of course, we'll bring it to you here on the SABC News Channel.